Evening, everyone. Thanks for joining us at Dingy Marshall for the second webinar that we are hosting. I must take a moment just to apologize. We had some, as they say, technical issues yesterday. Unfortunately, the internet line that we are running on wasn't allowing us to broadcast. So rather than attempt a very awkward exchange between Peter and myself, we thought that we would shoot a webinar and answer some of the queries that you sent in by email or commented. And we'll be going over those queries for the next hour or so. Once again, I'm joined by my colleague, Peter Turner.
Hi, everyone.
As in the previous session, I will be taking you through some of the new regulations and some of the impacts that those regulations have on contractual issues. And Peter will be addressing some of the same issues and giving a particular focus on labor law and employment issues. I thought maybe we can start, Peter, with a roundup of some of the regulations that we saw coming out this week. If you could perhaps take us through them.
Sure. So as Matt mentioned, I am responsible for dealing with queries that are more along the labor law lines of expertise. But oddly enough, the labor law sphere with regard to the regulations has been very, very quiet over the past 2 weeks, especially since the creation of the temporary employee-employer relief scheme. So what I will be going through with you this evening is just a short roundup of a set of amendments that were published last week, Thursday, to the standing lockdown regulations. So one or two important ones, the majority of them were foreseen because, the public have had a good 10 days to comment and criticize the previous set of lockdown regulations. And it seems like governments have mostly adhered to the foul cries that they have received from the public in the last 10 days and have made one or two common sense amendments to the directions and regulations as they stand. So firstly, the main one that would affect your general person on the streets is that we are now allowed to travel to attend funerals and cremation. So we are allowed to travel between metropolitan and any other districts, and we are also allowed to travel between provinces. There are obviously some caveats and some criteria that need to be met before we can do this lawfully. So the definition of a gathering in terms of the previous lockdown regulations has not been amended. In other words, this funeral or cremation that you will attend must still be 50 people or less in size. Also, if you intend to travel to a funeral or a cremation, you will need to apply to your local police station or your local magistrate at a magistrate's court for a permit to do so. You are required to fill out a standard prescribed form, submit it to the said magistrate or the police station. They will then issue the permit if everything is in order. Not only will you be required to produce that approved permit upon being requested to do so, you also need to be able to prove the death of the person whose funeral or cremation you are attending. So this you will need to be able to disclose at the time of making application for the permit before the magistrate or the police, particular police officer you are discussing this with. And also if you get stopped after the fact during your travels on your way to this particular funeral or cremation that you are attending. Another question that you may have is whether anyone can attend these funerals, whether it can be someone who you have been friendly with, a co-worker, or whatever the case may be. The answer to that particular question is not straightforward. It seems like the amendments to the regulations seek to limit, for obvious reasons, who can attend these funerals or cremations, and it's mostly restricted to family members, although there is provision made for someone to prove that they have a sufficiently close affiliation to the person who has passed away. So that's just a short overview of the new allowance to travel for funerals or cremations. Secondly, and I think the majority of us would find this quite positive news, it seems like debt collectors have been added to the list of non-essential services. However, the practical implication of this barring of debt collections during the lockdown is a bit unclear. We are not sure whether them being added to the list of non-essential services means that debt collectors who can function remotely and virtually from home have to cease placing telephone calls to you, or whether this simply just impacts on their ability to issue letters of demand and issue court process.
And then, sorry to interrupt, I assume debt collectors is to be understood in the meaning of debt collectors as such, and not attorneys or accountants or other persons who might be following up on outstanding debts.
That's correct. So the definition of debt collectors in this particular instance would relate mainly to call centers, those who kind of conduct pre-litigation collections. So I think the majority of us would have been on the wrong side of receiving a call from one of these individuals. So that's what it would relate to. It would not necessarily apply to litigation attorneys who are collecting funds in the course of their normal functions as litigants.
Yeah, I suppose. I mean, from our side, you and I were discussing off air the implications of the court lockdown regulations or the directions that were published by Minister Ronald Lamola. And obviously we've seen that interesting debate play out between the Minister and the Chief Justice, Mogoeng, and whether or not the ability to make regulations to regulate the court process should fall within the area of competency of the judiciary and not the executive, and obviously that becomes then a separation of powers issue.
Very much so.
The reason I mention is that either way, we've seen practice directives which have been along the lines of the directions. I'm not sure, it's a little bit too early to comment on whether or not we'll see challenges to Minister Lamola's regulations and directions, but certainly our practice has been affected. We've seen timelines suspended, we've seen both the directives and the individual court practice directives coming out of, for example, the Western Cape High Court, stating that no new summons and no new process will be issued, subject to certain exceptions. So things like matters where prescription is at issue, and of course the as yet undefined essential matters, and matters which are still urgent. I know you and I have both done articles on these topics, so it's probably worth mentioning that I will link the articles which we've been working on during the COVID crisis in the video below. I think you can also access those articles from our website, which is also linked. Yeah, and obviously this has an effect on our practice has been running, but certainly we are finding ways to assist clients, and we're still giving advice from isolation. I personally don't have any urgent matters on the go at the moment, but as I said, urgent and essential matters we can still proceed to court on, and in many ways it's giving us a chance to work on some of the documents that we have had to attend to. And I think what I've been advising clients is just to take this time to prepare affidavits, summons, etc., for the purpose of issuing once the lockdown ends, so towards 17 April, on the assumption that the lockdown is not extended. So perhaps, Peter, the other regulations that you mentioned were updated this week.
Yes. Yeah, so I've already mentioned the amendments relating to allowances for travel to attend funerals and cremations, as well as the inclusion of debt collectors to the list of non-essential services. A very important and perhaps somewhat, how can I say this, rights impacting amendment has been the introduction of what is called the COVID contact testing. So what this in essence does is it places an obligation on public and private COVID-19 testing houses to upload the results and various pieces of personal information from the people that they have tested, whether these have tested positive or not, to a nationally created COVID-19 database that is being administered by the National Department of Health. Now, this database will, for obvious reasons, be used to trace and locate individuals who have been in contact with either someone who has been a confirmed case of COVID-19 or someone who's reasonably suspected of having contracted the disease. So an issue also arises, or may potentially arise, by the following inclusion in the amendments or the regulations. And this allows the Director General for Health to direct an electronic service communications provider without any notice to the relevant person on who it is relevant to provide the Director General with information relating to that person's last location, their physical movements throughout the country, and they will then use that information to trace anyone that a suspected COVID case may have been in contact with. Now, this all seems good and well, and desperate times do call for desperate measures, but ultimately what this is a direct limitation of an individual's right to privacy. I'm not saying that this particular limitation is unjustified or unreasonable. There are quite a few additional regulations and preventative measures that have been introduced in the amendments to kind of lessen or minimize the effect of the limitation of the right to privacy on your everyday person. So an example of that is that this information can only be kept for 6 weeks after the lockdown ends. So after 6 weeks, or within a 6-week period after the finalization of the lockdown, whether it's extended or not, that information needs to be firstly de-identified. In other words, the person to whom that information relates, their identity must be removed or must not be able to be linked to that information. So the information will then still be retained, but it will be used on an anonymous basis and for medical research or whatever the case may be. Also, every person whose information has been shared in this way, especially through a directive by the Director General for Health to an electronic service provider, has to be advised of the fact that their information has been collected, has been used, and has been stored in a database. This is in alignment with the provisions of the POPI Act, the Protection of Personal Information Act. And we expect to see quite a bit of movement on this particular aspect of the amendments, because there will be individuals who will be unhappy about the curtailment to their inherent rights of privacy, which is something that will need to be challenged in the courts if that person believes that the government attended to this particular limitation without proper justification and on an unreasonable basis. So watch this space.
I think it's probably a good time maybe to just discuss online what some of the conversations that we've been having offline with regards to constitutional limitation of rights. For those not familiar with it, the right to privacy is enshrined in our Bill of Rights in the Constitution. And I think over this period we've seen a number of articles from academics and news reporters, journalists, touching on the issue of the impact of the regulations, the lockdown, and even the state of disaster, which was declared on individuals' rights and constitutional issues which arise from those regulations. Peter, with your constitutional background in mind, perhaps could you just explain the limitation issue in the context of the Bill of Rights for the viewers out there?
Okay. So South Africa's written constitution is considered to be one of the most progressive in modern history, in that it includes a Bill of Rights with specified rights and broad-ranging rights. So, I mean, our constitution, and specifically our Bill of Rights, includes personal rights, political rights, and socioeconomic rights. So what I mean by socioeconomic right is a right that places an obligation on the government to provide minimum water, electricity, adequate access to housing services, those types of things. And we're one of the few constitutions in the world that actually provide socioeconomic rights. So one of the first things that you're taught at university when you are dealing with constitutional law and human rights issues is that human rights must always be considered to be absolute. But ultimately, if these are limited by government action, either through the promulgation of some form of legislation or regulations, as we're facing right now, that infringement of a right will not necessarily be automatically unjustifiable or unlawful. The government or the party who has created this piece of legislation that impacts or impinges on a particular right must be able to show that the limitation of the right is reasonable and justifiable. Now, there is a built-in mechanism in our Bill of Rights to deal with these types of issues, and it is found in Section 36 of the Constitution. It's also colloquially called the Limitations Clause for obvious reasons. So how this would normally work is that if an individual believes that one of the host of the rights that they are bestowed with in the Bill of Rights has been infringed by government action, they would have to challenge the constitutionality of that governmental action. The response from the government would be to rely either on a statutory limitation right, such as we find in the regulations themselves, or they would have to rely on Section 36 of the Constitution to prove that whilst there is a limitation of the rights, that limitation was reasonable and justifiable. Now, it is quite difficult to give a specific rundown of how this particular section will function. It normally comes down to an element of reasonableness and whether any less drastic measures were available to the government to reach the purpose or to attain the purpose of that piece of infringing legislation that they did publish. So it will, in essence, come down to a balancing of the two competing rights. So in the scenario we face at the moment, so let's just deal with the contact tracing issue and the impingement of the amendment on the individual's right to privacy. Any court faced with a challenge to this particular amendment to the regulation would have to look at, firstly, on the one hand, the government's duty to protect its citizens from a very quickly spreading pandemic and the need to take emergency action in terms of the Disaster Management Act versus the individual's right to privacy. And the court will weigh those competing interests, consider all the surrounding facts, and then make a determination as to which rights or which interest would carry more weight in that scenario. This does not mean that the government's principles or the government's interests will always outweigh that of the citizen, but it is a fact-finding mission and a case-by-case type determination that needs to be made. So the normal course that an individual would have to follow in these circumstances, they would wish to challenge the contact tracing program on the basis that it is an unlawful and unjustifiable infringement to the right of privacy, to the right to privacy, is that an urgent application would have to be made to court seeking to set aside the amendment to the regulations on the basis that they are unconstitutional on the grounds that it is an unreasonable impingement of the right to privacy.
Yeah, and as you know, we've seen one, or as far as I know, there's been one challenge on a constitutional basis that has already been heard by the Constitutional Court. I believe it's the Holler-Bon NPC, which took the president to task, and I think that matter was dealt with quite conclusively. I must say I wasn't a big fan of the arguments raised in the papers,
yes.
But it was nice to see that our court didn't waste any time in dismissing the application and finding that, at least on the arguments raised in that application, that the president's actions in declaring the state of emergency were not liable to chat, or were justifiable, I suppose you could say.
Exactly.
I think you're right. There will certainly be more challenges as things progress, and I think certainly if you look at the practical timelines of such a challenge, we currently it's the 7th of April, so the lockdown is due to end currently on the 17th.
In 10 days.
Yeah, so I think that's a fairly tight turnaround time to get an application in and out of court. So I would think that unless papers have already been issued and served, with the lockdown currently ending, it almost wouldn't make sense for a challenge at this time.
Yes.
However, I think the hot topic or the issue on everyone's minds at the moment is whether or not the lockdown will be extended. And I think if the lockdown is extended, then you could expect a few more challenges which might be launched.
Definitely. No, I think most attorneys would advise clients who approach them at the moment on the basis of seeking a challenge on the basis of unconstitutionality aimed at one of the regulations or an amendment to the regulations, to perhaps just hold on for a few days to see whether there will be an extension of the lockdown. I think you're dead right in that if there is in fact an extension of the lockdown period, we'll see a lot more legal challenges, especially with regard to the constitutionality of the rights that are being infringed. So it's going to be an interesting time the next couple of weeks.
Yeah. I think maybe just from my side in terms of the updates to the regulations, I think in the first week of the national disaster and then the first week of the lockdown, there's a hurry to see what governments talk and what their announcements were going to translate into in terms of the directions and the regulations. And I think to some extent that has sort of settled over the past week. We saw, as you mentioned, various amendments and clarification, often in the form of guidelines that were published to try and interpret some of the regulations that had come out. Obviously, the legislature is under pressure to draft such documents in a very constrained time, and it's possibly not enough time to give full consideration to all of the issues. But certainly from my side, I can't recall any groundbreaking regulations which which would have a further impact. What we did see were amendments, for example, to the disputes and complaints process with relating to the competition law and consumer protection regulations which were published. So there's essentially sort of a freeze which has been put on non-urgent matters at the Competition Commission, and so too at the Consumer Ombud, where sort of focus and priority is given to things like price gouging, like we mentioned in our article and in the webinar in the previous week. So really to deal with the crisis at hand. We also saw various amendments in the CASA regulation. So we saw things like the fact that all websites operating off the domain .co.za must now contain a link to the COVID-19 or the government's COVID-19 website. We saw, I believe it was on Monday, that regulations were published in terms of which an SMS is required to be sent twice a day regarding COVID-19 updates. So I think that once that is in effect, then those SMSs will start coming through. But it's really sort of information spreading, that sort of thing that I was noting, or that I noted from the regulations this week. With that,
can I touch on one further important, not particularly important, I would say, specifically to in the sphere in which we practice, but I think another important amendment, and which has probably allowed government to avoid or circumvent a constitutional challenge, would be the inclusion of informal traders to the definition of essential services, and those who may now continue to sell essential goods from wherever informal traders function.
Yeah, initially a very hotly debated topic.
Exactly. And many scholars believe that the exclusion of informal traders from the definition of essential services may have amounted to some form of indirect unfair discrimination against those individuals on the basis of race.
Yeah.
The reason why scholars have said that is because it seems objectively that the law or the previous definition of essential services only impacted on informal traders, whoever they are and wherever they may be found. But the fact of the matter remains that the majority of informal traders throughout South Africa are African. And ultimately, it would have a disproportionate and unfairly discriminatory impact on those individuals if they were not allowed to conduct their trade. And government has luckily heeded these warnings or these early signs of potential conflict later on. And informal traders have now been included in the definition of essential service providers, provided that they apply for and are duly approved for a permit to conduct their various tradings. And obviously provided that they do sell essential goods.
Yeah, I think it's a good point you raised, because a lot of these regulations might not seem per se discriminatory, but sort of the knock-on or the effect of the regulations may amount to a discrimination on the basis of grounds such as race. It actually made me think very briefly of another article which I saw, which related to the movement of homeless persons. Now, obviously, as you mentioned, we have certain socio-economic rights which are enshrined in our Bill of Rights, and one of those is the right to housing. I think this has always been somewhat of a contested right in our Bill of Rights, and you would have seen that various municipalities have struggled at times to ensure that this is delivered upon. And now we are dealing in a period of lockdown where parties are, or persons are, confined to their place of residence. Now, when you consider the position of a homeless person, that becomes very problematic, because how do we define what place of residence is? If on the one hand, parties are prohibited from, usually in terms of city bylaws, etc., are prohibited from erecting shacks and shelters in public areas, and at the moment we have a prohibition on the movement of persons in public areas and a confinement to residential to places of residence. So I think there's a fair amount of challenge and debate and dispute which could occur on this particular topic. I have seen that at least in the Western Cape, that homeless persons have been moved from some of the inner city areas and some of the more overly populated areas in an effort to expand the sort of social distancing measures to more spread out areas. So we saw that a sports club in Strandfontein has been set up for homeless persons. We've seen the city erecting sort of areas in and around the Cape Town metropole for similar purposes. And I think, to be honest, that for me raises another issue, is that it might be a positive goal or purpose to move these persons into those areas now. However, once you allow those occupiers to reside in that area for any length of time, you might quickly find yourself in an issue where at the end of the lockdown, or at the end of the state of disaster, you now are faced with the prospect of evicting these parties. And then we have a further issue. We have the competing rights of the right to housing, and obviously the PI Act dealing with evictions would most likely apply, or certainly in my view. But it's going to be interesting over the next few weeks and months to see how that sort of plays out. Certainly something to bear in mind for when this period ends.
No, you did right.
Unless you have any other regulations or new directions which you'd like to comment on, should we move on to some of the queries that we've seen raised over the past week or so?
Yeah, let's do.
So, thanks to everyone who sent in comments and queries and questions. We've done a little exercise in collating these queries, and what we'd like to do is just discuss some of the issues raised and take you through some of the queries. I think, going along with the purpose of these webinars, these are often comments and queries raised which are common to many people. We're all dealing with a new situation. We're all dealing with this unprecedented lockdown. So it's important that that this sort of discussion is had. So Peter, I see, working off the list that you sent to me of client queries for the week, I'm going to start with query number 1, and that was, can it be said that the new COVID-19 contact tracing process infringes on the citizen's right to privacy? I'm not sure if you want to address that again, but we sort of covered that earlier.
But as we discussed earlier, I don't think there's any doubt of the fact that this is a limitation on the right to privacy. I don't think there's any way that you can spin it any other way. But ultimately, what it comes down to is whether this limitation is justifiable or not, and whether it's reasonable or not. And in my personal opinion, having read the amendments to the regulations and the various steps that the executive have taken to ensure that this personal information would only be used for beneficial purposes, that will ultimately be de-linked or de-identified from this particular person's status or their profile, I think that has introduced adequate safety measures to kind of bring the limitation within the realm of reasonableness. So whilst there is in fact a limitation of the rights, I do not believe that limitation is unreasonable and therefore unconstitutional.
And it fits within the bounds of the limitations clause in the Constitution. Okay.
Very much so, yeah.
The next query that we had was whether or not the government is legally entitled to prohibit the transportation and distribution of what it believes to be non-essential goods. I'll take a first stab at that, if you don't mind. So I think on a very plain language reading of the question, is the government legally entitled? Yes, it is. It has published regulations, and the restriction on the movement of those of non-essential goods is in terms of the law. I don't think we would have a challenge, or certainly not on a legality basis. It seems that the regulations were well issued, etc. I think perhaps the underlying question here is, again, relating to constitutional rights. So a party's, perhaps a restriction on a party's freedom of movement, freedom of trade, those sorts of rights are perhaps at issue. Whether or not we'll see a challenge on this, I think perhaps speaks to what we discussed earlier. If the question is only another 10 days of the lockdown, then perhaps not. If we see an extension of the lockdown period, and a considerable extension, if, for example, government were to announce a 2-month lockdown period from the 17th of April, I would think then that parties start considering whether or not it's maybe commercially viable to bring such a challenge, and whether at that stage it becomes a considerable limitation which perhaps is liable to challenge.
Exactly. Yeah. And I agree with you. I think the regulations have likely removed any unlawfulness that there may have been with regards to the prohibition on the transportation and sale of essential goods. But there is quite an interesting element underlying all of this. I mean, if you look at Section 27, subsection 2 of the Disaster Management Act, in terms of which President Ramaphosa declared a state of emergency or a state of disaster a few weeks prior, you will see that Section 27 does not explicitly authorize the government to suspend or limit the sale of what it considers to be non-essential goods. The only specific goods that are mentioned in Section 27, and this is mentioned in Section 27, 2, subsection 1, is the sale, dispensing, or transportation of alcoholic beverages in the disaster-stricken or threatened area. Now, an interesting point, and I mean, this comes down to legalese and the legal field of interpretation of statutes, but it's quite interesting to see that non-essential goods were not specifically or expressly dealt with in Section 27 of the Disaster Management Act. So an argument can be made that the legislature's initial intention when drafting Section 27 was to specifically exclude non-essential goods, thereby depriving governments of the right to limit the movement and sale of those goods during a disaster period. So what I'm saying is not that it is necessarily challengeable, but that there may be grounds ultimately for arguing that government may have acted outside of their powers by declaring a prohibition on the sale and movement of non-essential goods. But ultimately, I think if this is brought before courts, I think the nature of the regulations and the fact that they do deal with non-essential goods, and to my mind make a reasonable case for the exclusion of certain non-essential goods, will probably be found to be lawful.
Yeah, it's we keep making this point that we're living in unprecedented times. We're testing regulations that have never been tested. We're testing an act which has never been tested.
Exactly.
And as much as we're finding this with contracts, in that often the force majeure clauses that we're dealing with didn't foresee a airborne respiratory disease originating in China coming across, affecting a global lockdown period and causing a national state of disaster to be declared. It's almost inconceivable that the legislature would have considered such a unique position or such a unique situation to arise. So I think that there's a lot of there are many novel legal challenges and issues which arise, and which leaves a fair amount open for interpretation and challenge. It's interesting to see if the regulations on that basis then do get challenged.
Yeah, I do think the legislature has luckily covered or provided like a catch-all type of safety net in Section 27. So Section 27, subsection 2N authorizes the government to take...
Peter, would you mind just sharing
Yeah,
that section for us?
of course. Let me just bring it up. Okay, so you should all now see the front page of the Disaster Management Act.
Yeah, got it, yeah.
Okay, cool. I'm just going to scroll down until I get to Section 27. So as Matthew and I were discussing, Section 27.2 is the more important clause or provision in the Act that we are dealing with. So it states that if a national state of disaster has been declared in terms of subsection 1, which has happened, the minister may, and after consulting the responsible cabinet member, make regulations or issue directions or authorize the issue of directions concerning various grounds. So if you go through these one by one, you will not find the regulation or movement or prohibition of the sale of what the government considers to be non-essential items. You will see the only specific good that is mentioned is the sale of alcohol. I'm just trying to find it here. Yeah, there we go. 27.2I, the suspension or limiting of the sale, dispensing, or transportation of alcoholic beverages in the disaster-stricken or threatened area. So this had to be looked at in a vacuum. An argument can be made that had the legislature intended to specifically exclude the sale of non-essential goods, it would have been included in this particular section. But as Matt mentioned, we are finding ourselves in novel and unique times, and it would be particularly unfair for us to require our government to be soothsayers or fortune tellers in any way, that they've been able to see this type of thing coming and adequately make legal preparations for it. But as I mentioned to Matt earlier as well, you will see that Section 27.2 subsection N, which I will highlight for you here, kind of provides a nice catch-all or safety net for the government to kind of justify their limitation of the sale of non-essential goods. So it gives the government the right to give directions or regulations on any other steps that may be necessary to prevent an escalation of the disaster or to alleviate, contain, and minimize the effects of the disaster. So I think if one looks at that.
So, and then perhaps also Section 27.2, I don't know if it's E or F. If you scroll up slightly, you'll see it. F.
Traffic movement and goods,
yeah.
Yes.
I think there's a fair, you would think that the legislature has a little bit of wiggle room perhaps to apply generous interpretation to 27.2F, and as you say, the catch-all provision of 27.2 that you highlighted.
But the interesting thing about 27.2F is that it doesn't make explicit reference to the sale of goods. It just mentions the regulation of the movement of goods. Whereas I, which deals with liquor, specifically prohibits or gives government the right to limit the sale, dispensing, or transportation of alcoholic beverages. But as you mentioned, I believe Section 27N will allow government to comfortably circumvent any challenge to the regulations with regards to the sale of non-essential items.
Okay. I think that addresses the query. Should we move on to the next one?
Yes, let's move on.
I think, you had a query on attending funerals or cremations. I think we addressed that earlier on, so I don't think we need to revisit it. And I see you've addressed query number 5, spaza shops trading as well. So should we push ahead? I think one of the ones which we have been asked by sort of clients, friends, and family is, can I buy cigarettes? And I see this is receiving a bit of time in the news and the media.
Yes.
Once again, you and I discussed this sort of offline, but it's probably worth repeating what we went into. Now, cigarettes aren't specifically dealt with or aren't exempted as an essential good, so it fits in the same sort of category as alcohol. It can't be sold during this time. We saw an interesting interpretation come from in my view, and with respect, an interesting interpretation coming out of the Western Cape government. There was James Force and Alan Windey. I believe they set out guidelines saying that the sale of cigarettes is not prohibited per se, and that seems to conflict with what our Minister of Police, Becky Kele, has said. My personal view is that the regulations will, I'm just going to pull up the page here. My personal view is that the regulations will prohibit the sale of cigarettes, and it's done so on the basis of regulation, the amended 11B, whereas and sorry Peter, I realize I'm not sharing this document with you on your side. I do have
no, that's fine, no problem.
Broadcast. The regulation 11B of the disaster management regulations, which we've been talking about, quite rightly do not specifically address the sale of cigarettes. However, regulation 11B 1D states that retail stores selling essential goods is prohibited from selling any other goods. So retail stores selling essential goods are allowed to stay open, and grocery stores, etc., selling essential goods are permitted to remain open. However, as per that regulation 11BD, they are prohibited from selling goods which are non-essential goods. So, for example, if you happen to walk into Woolworths Food, who also sells clothes, or which also sells clothes, you can buy the food, and I believe most stores are now stationing employees at the doors to advise parties not to go into areas which contain non-essential goods, and that you can't purchase non-essential goods. I know that's the experience I had when I went to the shops on Saturday. Peter, your views on the cigarette sales?
Yeah, no, I fully agree. I think ultimately what is considered non-essential, especially with something as controversial as cigarettes, is very much a subjective issue, but it is ultimately up to our national government to guide us on this. I think the Western Cape government probably overstepped the limits on their power, but I think it was probably a wise move to reduce their queries to writing after being called out on their overstep by Becky Cele, as you mentioned, and to direct these queries to the office of the presidency and to request some clarity. I think that is probably the most that can objectively be done during these times. And I think a lot of this will depend on what the presidency comes back with. But I think you're dead right. And as it stands now, as the regulations read, cigarettes are not considered an essential item, and and that the power to limit its sale lies exclusively with the executive.
Yeah, so we'll see if any disgruntled customers end up challenging that one. Just having a look at some of the other queries that I raised, or that have been raised in the past week. This is perhaps a more broad topic, but should I look at going into liquidation? Seems to be a hot topic. I know that you've dealt with many retrenchments, many reductions in salary, that sort of thing. Obviously, with the crisis and the economic effects that it has, people are looking to limit expenses, limit expenditure, trying to reduce costs. And one of the easiest ways to do that, or one of the possible ways to do that, is to reduce your wage bill, your salaries. I think the more extreme step is to look at fundamental actions which might affect the company. So things like liquidation and business rescue are being discussed quite a lot recently. I've had a few discussions with clients and interested parties trying to find out what the process is. I think the other issue which seems to have raised its head, which directors are particularly concerned about when they discuss liquidations, whether they can be personally liable. I had this discussion with the client on Thursday, and my advice on the question as to whether they could be held personally liable was, it depends on the circumstances. In general, personal liability of directors is limited to where the company can be said to have been trading recklessly, and that can be interpreted as being with the intention to defraud creditors or trading in insolvent circumstances. Now, liquidation, as soon as the company is commercially insolvent, and when I say commercially insolvent, I mean that in the company law context, and that would mean that a company is unable to pay its debts as and when it becomes due and payable, as and when they become due and payable. So at that stage, if your company is approaching that stage, you should be considering liquidation. If the company is in fact insolvent for the purpose of that definition, then it can be argued that a director is allowing the company to trade recklessly if the company is allowed to continue trading. So should I look into liquidation? I suppose the crux of the question comes down to whether or not the company is commercially insolvent. I suppose one step prior to liquidation would be business rescue, and the test at business rescue is not commercial insolvency, but it's financial distress. So if the company will be commercially insolvent within 6 months, is the generally accepted norm for the requirement to put a company into business rescue. Whereas liquidation is very much a final act. The company is wound up, the juristic personality of the company ceases to exist, and the assets of the company are sold off, and the residue of those assets are then distributed amongst creditors and shareholders. Business rescue is somewhat of a turnaround time for companies. It's I think of it as a sort of last chance saloon before a company should be put in liquidation. And if the business rescue process is successful, then a company can, in many instances, continue to trade and trade successfully. If the business rescue process is unsuccessful, then our case law requires that the business rescue practitioner puts the company into liquidation. It's a topic that, as I said, we seem to be receiving a lot of queries on. We're happy to advise further, and it's very much a case-by-case basis that an assessment that needs to be made. So please do feel free to contact us if you're staying up late at night wondering about your personal liability. That takes care of 2 or 3 of the queries that I had. Another one which I believe was raised last week was relating to landlords and the obligation to give a reduction in rental. I'm not sure if we should discuss that issue again. In summary, in most cases that we've looked at, it does seem like a commercial tenant has an argument to request a reduction in rental. In residential leases, not so much, but very much a case-by-case assessment that needs to be made, very much an exercise in reading and understanding your lease agreement before we can
your landlord.
advise. Sorry?
And your landlord.
Yeah. If you have any queries on that, please feel free to reach out. You can contact us on the email addresses on the website. And we are happy to advise on those topics. One of the ones I had, Peter, which perhaps you can answer best, is my business cannot run in the lockdown. Must I pay my staff? Must not, I suppose it's not a question of how much, it's do we have an obligation to pay staff?
Yeah, I think what it comes down to, if you look at the pre-lockdown situation in our labor law, was that whether your employees attend work or not, if they are willing and able and available to work on that particular day, whether you allow them to work or not, they should be compensated for that particular day. So technically, if you look at your lockdown period where non-essential businesses have been forced to shut their doors, if you apply the pre-lockdown position, you could easily argue that your employees are willing, able, and available to work during the lockdown. They are just legally prohibited from doing so. So the situation would remain the same. You remain obligated to pay remuneration to your employees, but obviously these are drastic times, and they do call for novel and creative solutions. So what we normally advise our clients in these types of scenarios is, whilst the fact that an obligation to pay remains relevant, it may be a good idea, given the novel circumstances and the strange times we find ourselves in, to reach some form of agreement with your employees that they will work either reduced time and therefore at reduced wages or salaries, or where you agree to a extended leave of absence, unpaid leave of absence during the period of the lockdown. Obviously, that is not ideal for employees, because employees have families and also need to be looked after during these times. But that can be circumvented by looking at an employer applying for some form of benefit or assistance from the temporary employer relief scheme, which will allow an employer to draw a certain amount of money per month from the UIF, pay that across to the employees. It may not cover the employee's full salary, especially where these employees are working at reasonably high levels within the employer, something to live off during these difficult times.
Okay. Yeah, I think that answers the question. I would encourage people who are interested in that sort of topic to go rewatch the previous webinar. And then, Peter, I know you've done quite a few useful articles that are on our website, and as I said, that I will link in the comments of this video. Just running through these questions. This one I haven't come across as much, but I suppose it bears it's a useful one to discuss, and that's: can my landlord evict me if I can't pay rent? So I think first of all we should separate the two concepts of legal occupation and the obligation or the ability to pay rent. So on the topic of eviction, the reason a landlord can evict someone is always down to the legal right that party has to occupy those premises. So if, for example, you have a lease agreement which is in place, and perhaps you haven't paid rent for 12 months, for so long as that lease agreement remains in place, that landlord is unable to, or doesn't have the right to evict you. What is required first is that legal right to occupy the premises must cease. And in the context of a non-paying tenant, that would mean that the cancellation procedure of the lease agreement would have to be followed. If, for example, if the tenant is a natural person, then the Consumer Protection Act would apply, and in terms of Section 14 of that Act, you would have to give the tenant 20 business days notice to remedy the breach being non-payment, and only after that 20-day period has ceased would the landlord be able to cancel the lease by delivering a second notice, or a notice of cancellation. And at that time, the legal right to occupy those premises would cease, and the landlord could then approach the courts for an eviction order. It's probably worth mentioning that at this stage, in a very short answer to your question, can my landlord evict me? Whether he can or he can't, at this stage he cannot, because the courts are not entertaining eviction applications unless they pertain to essential or urgent matters. So I hope that answers your question. Peter, here's one which I believe you have you've addressed, and that is: can debt collectors and attorneys still phone me in lockdown for outstanding debt, and can they still issue letters of demand? I don't know if you want to revisit that, but maybe a quick summary on what we discussed earlier.
I have a quick answer. So firstly, it's important to draw a distinction between a debt collector and an attorney. Essentially, a debt collector has been included in the list of non-essential services. So in a perfect world, no, debt collectors are not entitled to function at the moment. Their call centers are supposed to be on lockdown, and are not supposed to be functioning. But then again, whether they are allowed to work remotely is a different story. If you move to the other side of the coin and look at an attorney contacting you for payments and issuing letters of demand, there again, litigation services were included in the list of essential services, and therefore you could conclude that therefore attorneys performing debt collections may continue running their operations.
Okay, thanks, Peter. I'm trying not to address queries that I think we might have addressed earlier in the previous session. Yeah, just having a look here. One of our clients sent through a query saying that banks are taking advantage now by offering loans as people are desperate, but they are charging exorbitant interest rates. I'm not sure if exorbitant is meant to mean rates which are particularly high during the crisis, or if these are rates that were, if this is just a general complaint about the interest rates that banks are charging. This is not legal advice, but as our repo rate has been slashed, I would think that this is possibly one of the better times to be getting loans. I'm not sure, and I haven't actually considered this in the context of the regulations published in terms of the Competition Act and the Consumer Protection Act, and that's whether or not banks charging excessive fees during this time might be prohibited from doing so in terms of the price gouging regulations. I think if you are in need of financing and you have received a quote which is in your mind excessive or above, perhaps normal rates, then it's probably something worth contacting us about, and we can have a look at the proposal by the bank and perhaps judge whether or not the price increases would qualify or would be considered price gouging as per the regulations. And if that is the case, then I suppose you would have relief in terms of reporting the bank or the finance provider in terms of the Consumer Protection Act or the Competition Act. We have a question here. It's a criminal law question. I suppose we might as well have a crack at it, Peter. Can you get bail if you are arrested under the regulations of the Disaster Management Act? Peter, would you like to have a first run at that?
Yeah, I'll have a go at it. I think the short answer is yes. As Matthew mentioned earlier, our courts have been placed on a diluted form of lockdown in that they remain open for certain essential functions, and those are for the bringing of urgent matters, to bring matters that relate to custody issues and maintenance issues, and also specifically to allow for bail applications. The ability of the court to deal with bail applications in these times has not been delineated, so it doesn't say only bail application relating to a specific level of crime or specific offense in terms of a particular act. It just simply allows courts to hear bail applications. So I would assume that would include any bail applications associated with an offense committed under the Disaster Management Act.
Yeah. I agree wholeheartedly. I think as much as a lot of these regulations have placed restrictions on what parties can and can't do, the right of arrested and detained and accused persons is enshrined in our Constitution, and the bail rights of the party certainly can't be limited just because we find ourselves in a period of lockdown. I can't recall offhand, but I do know that the bail applications which are being handled, the regulations have been published in terms of the Disaster Management Act to deal with those matters. So 100% yes, if you are arrested under the regulations, you will be able to apply for bail. Okay, I think that addresses the question. There are two questions here, which I think perhaps, Peter, you can address. They are somewhat related. The first one is, can my company retrench me because of COVID-19? And the second thing, the second part of the question is, when things are back to normal, can my company who retrenched me appoint someone else in my position without offering it back to me first?
Okay, so let's deal with the first one. Nice and simple answer. Can my company retrench me because of COVID-19? Yes, they can, most certainly. I would recommend, if I'm advising an employer, that they try and exhaust all other alternative resolution remedies available to them. So either going through some form of agreement with their employees, or going through an application for a benefit in terms of the temporary employer relief with the UIF.
Sorry, Peter. So that it's just sort of made me recall one of the other queries I had, and that's that, as companies are now going through many retrenchment process, that sort of thing, obviously the companies are still required to follow the provisions of the Labour Relations Act. That hasn't been suspended because of the lockdown or the disaster. I can't recall, but what is the position of the CCMA at the moment? So if, for example, an employee was aggrieved by the retrenchment process that was followed, what is the recourse to the CCMA during this period?
As far as I'm aware, the CCMA is on a similar lockdown to our general court system. So the CCMA would also not be issuing any new matters at this time. But luckily, the Labour Relations Act gives employees a relatively extended period within which to bring a challenge to an unfair dismissal in the event that they believe it was unfair. So normally an employee has to bring some form of challenge to an unfair dismissal within 30 days of the dismissal. I believe how that would function now is that that 30-day period would be suspended, and it would run again as of the date that the lockdown is lifted and the CCMA comes back into operation.
Okay.
But that's exactly. But you're dead right. An employee who's looking to retrench must still strictly adhere to the provisions of the Labour Relations Act, specifically Section 189, that deals with retrenchments. And maybe an interesting point to mention is that one of the major hinging points of the retrenchment process is active consultation between the parties affected. So it requires the employer who's looking to retrench to actively consult and engage with its employees and ensure that they are an integral part of the process, that the input is given, input is considered, and is then adequately responded to. The fact that we are now, majority of us are all in lockdown, does create an additional hurdle for the employer, because how does it adequately consult with its employees on retrenchment during this period? It's almost impossible for them to meet face to face, especially if you're dealing with a scenario where you are looking at retrenching employees who may not have access to online or electronic means of communication at home. What do you do? In those scenarios, it is unfortunately almost impossible to retrench in accordance with the law, and retrenchments may have to be put off until employers can adequately consult. But where you are dealing with a workforce that are all easily communicable through electronic means, and I have recently advised the client to do this, is to commence the retrenchment process and ensure that you can actively consult with your employees one by one, if needs be, via electronic means. And I think that should, given the novel scenario we're facing at the moment, satisfy the requirement for consultation.
Yeah, okay. Yeah. And then turning to the second part of the question, the employee makes the point when things are back to normal, so we assume sort of a post-COVID-19 lockdown and national disaster period, can my company who retrenched me appoint someone else in my position without offering it back to me first?
Okay, there are a few moving parts to that question. Firstly, a lot of it would depend on the discussion or agreement reached with the employees during the retrenchment process. So I've also recently advised a client. We delivered the Section 189 subsection 2 notice to commence the retrenchment procedure. And in it, we specifically mentioned that should the company be on a better financial footing once the lockdown ends, and should it look at bolstering its workforce, it would give preference to employees that have been retrenched during this period.
Okay.
The short answer to the specific question is no, that would not be allowed. That would be considered an unfair labor practice. So what we would advise in these scenarios is if employers are retrenching and if their financial situation does improve after the lockdown ends and they're looking at bolstering their workforce, that they need to look at rehiring the employees that they have had to retrench. Obviously, if that employee has found a better position somewhere else, and is no longer looking at rejoining the employer, then the employer would be within its rights to hire someone else in that position.
Okay, cool. Thanks, Peter. Running through these again. If the lockdown is extended and the president gives us a grace period of 3 days to get supplies before going into lockdown again, must you in those 3 days fulfill your contract suddenly? I think this is possibly a difficult one to address. First of all, the presidency, as far as I know, has not given any concrete indication of an extension. I do think that it would probably be reasonable to allow parties to sort of resupply, in as much as parties have been limited from purchasing certain non-essential goods and services during the period. It would make sense to allow those parties who have perhaps provisioned only for 21 days to then resupply for the extended period. Must you in those 3 days fulfill your contracts? I would think if you look at the obligation in terms of the contract that you are concerned with, let's use the example of perhaps an events booking company, something like that. I don't think that any grace period which is allowed would allow parties to perform. So in as much as a grace period allowed would be in relation to perhaps non-essential goods and services, I can't imagine then that an events company could perhaps tender performance in those 3 days and then demand counter performance, perhaps payment of the booking fee or payment of the event hire fee, something like that. Peter, your thoughts on that question?
Yeah, no, I'm in full agreement. I think it is quite a difficult one to answer accurately without having
Sorry, Peter. Okay.
Yes, yeah, Matthew, I'm in full agreement. I must also say that without having a decent idea as to what will actually happen towards the end of the lockdown we're currently in, it's very difficult to answer the question accurately, because you would expect that if the lockdown is extended by another month, and if we are given some form of grace period within which to gather our nuts, as it were, a whole host of new regulations and directives will have to be published to deal with those periods. And as Matt mentioned, it would be almost impossible for you to perform on the whole host of agreements that you are a party to within 3 days.
Yeah.
And even if you don't, your creditor would be a hard place to do anything about it within 3 days.
Yeah. Likely an academic question, because we're not sure how and when and if the president will extend the lockdown. Yeah, I think that's something that we'd have to consider on the announcement, and perhaps the government might, as they have done with many of the regulations, indicate some sort of guidance as to what is allowed and not allowed during this really a notional. What did she call it?
Grace period.
A grace period, yeah. Are there any queries on your side which you feel we haven't addressed?
No, the only one that I received, even though the answer is relatively straightforward, but I think it may be relevant to many people out there, is whether you are required to pay school fees during this period or for the next term. So at the moment, these types of payment obligations are dealt with piecemeal, but the Minister for Education has recently declared that all school fees must be paid up until the end of April. If the lockdown is extended, then they may look at the implementation of some form of relief scheme for both parents and schools themselves. But from now, if you have a child in school, especially if they're in public school, you need to pay up, at least until the end of April. Whatever happens after that, we'll have to wait and see.
Yeah, I had a discussion with a teacher, colleague of mine, who made the point that she's still a teacher and that she still needs to deliver online lessons, etc., during this time. And I understood her point. From an employer perspective, she is still required to put in a certain amount of hours to the school, but I think that perhaps that obligation should be separated from the obligation of a school pupil or school learner, and his or her parents' obligation to pay school fees. So, I mean, really, from a contractual perspective, I think perhaps we'll see more of this sort of query, of these queries after the period that you mentioned, after the Minister of Education gives further clarity on whether the lockdown is extended. But in as much as a contract that party has with the school obviously has some bearing on the commercial value which is expected. So, for example, in my friend's example, where she may be able to provide a limited education by perhaps webinars and online lessons, etc. There are other things which the school provides which it's not able to provide over that time period. So, for example, rugby fields or physical education, access to a gym facility, access to pools, things like that, which are per se not which are per se prohibited during this time. So, for example, for so long as the movement of persons is limited or the gathering of persons is limited, then why should I pay for the school fees associated for that large school hall or for those facilities? So I think that sort of thing is going to be tested moving forward, and there might well be an argument for a certain remission in the payment of school fees if schools are only able to deliver a certain portion of what they normally deliver. And that comes down to that sort of supervening impossibility discussion that we had in our previous webinar. And again, I would encourage you to go listen to some of the discussion that was had on that topic. All right, so I think from my side, that sums up most of the queries that I received. We will be doing another webinar in the future, so please feel free to continue sending through questions. Peter, is anything more on your side?
No, Matt. Yeah, I think I've dealt with all my queries.
Okay, cool, perfect. Thanks. Thanks everyone for joining us again on the webinar. As I said, we'll continue to discuss some of the legal issues thrown up by the COVID-19 crisis over the coming weeks. If you have any specific queries on the topics raised, or if you are in need of legal assistance, then we do encourage you to reach out. Our email addresses are linked in the video and on the channel page, and so too on our website. And then perhaps just one more word of thanks for bearing with us. Unfortunately, our live broadcast had to be abandoned yesterday. It just wasn't going to be a meaningful discussion with the internet speeds unfortunately letting us down. We hope to improve on that in the future, and we hope that our live broadcast can continue again soon. From my side, thanks so much for joining us. Peter, thanks so much for your time, and we look forward to seeing you all again. Goodbye.
Cool. Bye, everyone.